Okay, so good morning, everyone, and thank you once again for everyone attending and for everyone who's watching later on. Just administratively, just because anyone who's watching this later on in time, we're now at about 2,200 members in our group, which is really amazing and is a credit, of course, to all of you. Many of you are now asking me private DM'd questions. Please feel free to keep that up. Happy to address any of your questions that result from any of these discussions. And without further ado, I'm going to get started so that I don't waste people's time. I'm going to start by sharing my screen. Here we go. Can someone just quickly confirm that they can see what I'm sharing? I just don't want to go on without everyone. Someone can just in the chat.
It works.
Yeah, everyone can see? All right, fine. So what we're going to be talking about is the new build agreement. And I'm going to preface this. Because usually when we have these talks, people turn and they say, oh, great, I'm going to learn some great new trick to really buttress my side. And hopefully you will from this session, because I do have a couple of tricks up my sleeve. But what you're going to find as we kind of go through this is that the tricks that I am going to be showing you, the ways you can fight a builder, if you will, are not so much legal tricks as they are practical procedural tricks based on the way builders deal in volume. So let me stop and let me just explain for a minute. There really are only a couple of legal shops that represent builders in the city. And those shops, although they may appear competent on their face, are a beehive of tremendous activity where they barely know what's going on a per file basis. In fact, I believe we have one or two people on this forum right now who have worked in these shops. And while outwardly it may all appear gleam and shine, the truth is what takes place there is what in Yiddish they call a clusterfuck. And oftentimes, really what they're designed to account for are normalcy. They know how to respond to a breach of an agreement. They know what their agreements say. They have routine letters that they send out. And anytime you are able to break them from their routine by pointing out something that they are not used to, their default is to give in. And so what I'm going to talk to you about are ways you can fight a builder by pointing out things that most people do not, and in so doing, kind of get what you want from them. They aren't necessarily legal tricks, though some of them are. Some of them are just practical tricks, using the law in order to get it. And if what I'm saying to you doesn't make sense, it will as I go through. So let's get into it. So, new build agreement. Oh, you tricky builder, you. Aren't all builders good, nice, pleasant people? They sure are. Really? No. And I think anyone who's had any dealings with builders will particularly attest to that. So let's move. So the first thing I'm going to address today is disputing your final closing costs. Now, we are fortunate today to be joined by David Feld, and if you guys take a look, he has gone through building closing costs in great detail in previous correspondence. But what I would mention on this point is that there are any number of fees that are put into the statement of adjustments at the end of the day. Because oftentimes one of the fights that you can have with a builder is, hey, you're charging me too much. Those fights never really involve the small adjustment costs, which David went over very amply. Your carry-on costs, your meter installation, your law society fees, your blanket discharge fees, your trust reconciliation fees. I could go over what all these things are. But given that these are largely what the fees are that are being paid, these are never really the subject of great dispute. Where things get disputed is in the larger charges of the adjustment. And one way to fight a builder is by knowledgeably being able to take those charges on. Most lawyers cannot do this because most lawyers don't understand the math that underlies the actual large adjustment fees. And to be clear, those fees are really twofold. It's threefold, but practically the education levy is a set fee, so there's nothing really to be done. The three large adjustment costs are your DC costs, your Section 37 charges, and your education levies. And what causes the most concern for people right now is, in fact, your DC charges. I have caught numerous builders inaccurately measuring DC charges. And the way DC charges work, when you go to a lawyer and say, this number looks ridiculously high, is the lawyer says, oh yes, well, this is the fee that was negotiated, what can we do, there we are. And what they're actually saying is, I don't actually understand how these things are calculated in the first instance, and therefore I'm not going to get into the substance of the math. But figuring out how these things are calculated is actually not difficult. And if you go through the math, 1 time out of 10, 1 time out of 15, you will find that the builder itself is not making mathematical sense in charging your client. So let's go over what the DC charges are. A new purchaser is not responsible for paying all DC charges, which are development charges. Development charges are the tax levied on every new residential unit in a given jurisdiction. It's odd that the cities, by the way, on one hand, state that they want more residential units. Please, why won't builders build more? And at the other, levy development charges to the tune of about 60 grand or something in today's world. These are from a couple of years ago, from 2017. It's very odd that they charge this tax, but this is, I guess, one of the ways that they keep property tax down. And what happens is they build in the DC charges that they themselves need to pay as of the date the agreement is signed. Though there is a problem, and the problem is practical, and you have to understand the problem from a builder's perspective before you can fight it. DC charges crystallize at the time what's called an above-ground building permit is pulled. So let's contemplate how a normal agreement of purchase and sale goes. Someone builds a sales center. At the sales center, they actually know what their development charges are. They charge you $400,000 for a condo. Good luck finding one for $400,000, but they're charging you $400,000 for a condo. Part of that $400,000 encompasses the building development charge as it is in 2013 when this agreement of purchase and sale is signed. After the agreement of purchase and sale is signed, the municipal council, requiring more money for its budget and realizing that builders are an endless source of money, goes ahead and says, okay, we're raising the DC charges. It's now going to go up. It's going to go up to $40,000, $50,000, $60,000 a unit. And of course, the builder has only taken in money for $20,000 or $30,000 at the time it was signed. The builder now digs its hole. The builder then puts in the footing and foundations. And then the builder, only after the footings and foundations are in, can apply for the above grade permit. Once, I'm sorry guys, there's some background noise. I hope you don't mind. I'm just going to mute people. There we go. Once the above grade building permit is pulled, then and only then do the fees crystallize, which fees may be very different than what the builders had originally charged. And accordingly, the math is actually relatively simple. You look up when the agreement was signed. So in this example, I have an agreement of purchase and sale that is signed in 2013. And at the time, the city of Toronto, for example, has like an actual schedule. If you write DC charge schedule, it will give you 2013, 2014, 2015, 2016. It will give it all to you. So all you need to do is look up what it was in the year and the month that this was actually signed. And then you look up approximately, because in your own head, you're able to figure out when the above grade building permit was pulled. It's usually about, generally about a year before they're selling or before they're going into occupancy. Because remember, most of the work in a building project takes place digging the hole and putting the footings and foundations. Once you have that, it goes up very quickly. So you can figure out when the above grade building permit was pulled, or if you are in a real dispute with the builder, you can actually call up the city and find out. And then on the basis of that, you're able to simply do math. You could say, I'm dealing with a semi or a single. And I know that in 2017, these are real numbers from the city of Toronto. A single and a semi was charging $40,067. And I know that when I signed this agreement of purchase and sale, a single and a semi was coming in at $19,412. Therefore, the differential is $20,655. By the way, the reason I'm using these 2 years is both because A, I had this from a presentation from 2018, so I just didn't update it. But also because development charges went up significantly during the 2014-2015 years. And so there we go. And so the math becomes very clear. Now, generally, what you can do is if you understand what it is I've just said, and you get a statement of adjustments that shows $40,000, which, by the way, I have had in the past. I couldn't believe it, but I've had it on 1 or 2 deals. You look at it and you say, this number seems high. And then instead of going to the builder and going, what the heck, this number is high, you write a letter that says, dear sirs, or dear madam, here is the development charge at the time this was signed. Here's the development charge today. How the heck do you get $40,000? No, 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 your math is off. That is a far more powerful way of getting the statement of adjustments adjusted. In terms of education levies, as I said, it's very simple math. They're flat fees. They don't really make mistakes on the adjustment levies. I'm going to leave that, on the education levies. Section 37 charges, however, are the other big one. And the Section 37 charges can be any amount of dollars. And what it is effectively, if you are building above the zoning guidelines, the councillors used to be notorious for extracting individual recompense for their district. I want a park here, I want a new tree here, I want whatever it is. And the builders would just pay it because they needed to get their councillor on side. And it was an institutionalized form of bribery. And the city said, well, if we're going to have this institutional form of bribery, better that we do it on a citywide basis as opposed to councillor basis. And now Section 37 charges are the bribe fees that you need to go above zoning guidelines. The Section 37 charges are usually accurate and are a bit more difficult to figure out because they're levied on a project as a whole. But if you find that the Section 37 charges are huge, and you are not dealing with the biggest of builder law firms, requesting of the builder the background information behind the Section 37 charges is usually flummoxes them. Not because they won't provide you with a bevy of paperwork underlying the charge, but because they usually don't do a very good job of breaking down the Section 37 charges into the allocated units. That is to say, when I've looked at the Section 37 charges that I've found to be high, the builder has provided me with the underlying documentation for the Section 37 charges, but again, going into the math of the thing, you quickly realize that they haven't allocated it as against the parking units, as against the lockers, and are just simply doing in some instances, I've seen them just do a division as against all the units, as opposed to the allocated percentage of a unit, which is what you would expect. And so what I'm getting at here is the builder math, they're just people. It's not unchallengeable, but you do need a lawyer like David, like Sonia, myself, or others who actually understand this and understand the math that underlies the charges, such that instead of saying this looks high, I'll write to the builder and see what I can do and write a stupid letter that says these seem high, what the heck. You are writing a letter predicated upon the basis for which they are charging you and challenging that mathematical basis. It is critical, therefore, that you understand how this math works as a lawyer. Does that all make sense? I'm going to pause for a minute and I'm going to turn to other areas. Does anybody else have any questions so far? It all makes sense so far? Okay, good. Glad to hear. Let's move on. Okay, so let's start with other ways we can fight the builder. Let's start with disputing the right to assign. So you'll recall the way I started this conversation. Builder contracts are fairly ironclad. It is awfully hard to fight them. It really is. One of my mentors had an expression, my mentors in real estate had an expression that said, a contract is merely a collection of things that have gone wrong in the past. And the only person who is really amending their contracts to their benefit over and over and over again over the course of decades has been builders. And so the builder contract presently is an incredibly one-sided agreement, which gives the builders all rights in the world and really gives the purchasers very little. And the purchasers generally have no ability to negotiate that in any respect, though lawyers try through simple letters saying, hey, this contract needs to be amended in the following way. That's not really amending the equities of every paragraph of the contract. One of the things that the contract does is it denies you the right to assign. And I know a lot of you are thinking, well, no, I always negotiate that I have the right to assign. Well, the first thing I'd point out to you is that you don't. What you usually negotiate with the builder is the right to assign for $0. And generally, if you read through their right to assign, Schedule Z, it said, I don't have one here, but it says that the builder, if they choose to grant the assignment, will do so for $0. Now, practically, builders understand that many buyers are buying for the right to assign. And they'd be shooting themselves in the foot denying it, and as a result, they don't. And so I don't know of any instance where a builder has granted a right to assign for $0 and not allowed it to take place. But you should know that the simple wording says no. And oftentimes builders say, I'm sorry, we're not granting a right to assign. So the question has been brought to me many times as a lawyer, and I'm sure to David, Sonia, who are on this call, and others, well, can I assign? And the answer is no, you can't, not pursuant to the agreement. But the job of a lawyer is not always to think like a lawyer. Sometimes it's to think like a bully. And maybe we can figure out a way of doing this. How do we do it? So we send a letter. And the letter reads as follows. Dear Sir or Madam, we represent client X who's presently intending to purchase a property from your client, Builder Y. We're writing to inform you of certain circumstances surrounding our client's purchase. Our client has recently lost her job and as a consequence got divorced, and while recovering at home from the shock of those events, was randomly attacked by a pack of wild hyenas who, due to the grace of God, only managed to permanently handicap her left arm before a raging flood swept them and most of her house away into Lake Ontario. We've done everything possible to conclude this deal, but unfortunately, due to the circumstances described above, we will not be able to proceed. And in an effort to mitigate the builder's damage that will result from this circumstance, we found a credit-worthy assignee ready, willing, and able to assign this unit, and we'd be most grateful if you would consider allowing for the assignment in accordance with your contractual obligations to act in good faith in the performance of this contract. Absent the builder's indulgence in this regard, we'll be unable to conclude this deal on its terms. We thank you sincerely for your attention to this matter, and we look forward in response to your correspondence. So let's break this letter down. I know this seems funny, what I wrote over here. But what I was getting at there is you really are writing this not for the builder's sake, though you're writing for it for the builder's sake too, but you're writing it because the builder is going to look and say, how will this look to the courts? And if you're able to draft a sympathetic letter, as sometimes you can, oftentimes the stories that you get where someone is crying saying, I need an assignment. I mean, my last time I wrote this, I had an Army veteran who was diagnosed with cancer. That was actually the state of affairs, and I was able to write that all in the letter, and the builder gave back all of the monies, didn't even say the assignment was necessary. They just said, yes, we're prepared to just let you out of this agreement. The assignment was going to be for a loss in that instance. And the builder said, no, you know what, we're ready to just actually give you back your deposit. You don't even need to go through the assignment route. We're done. They were good guys actually there. But you're trying to tell a tale of hardship. And then you're trying to say to the builder, I understand I'm putting you in a place of damage, But you have an obligation pursuant to a case called Asamara, which is the standard case here in Ontario, to mitigate that damage. And I'm giving you the ability to mitigate that damage with a credit-worthy assignee. And so screw what it says and screw what your policies are. We are in the realm of contract. We are about to breach a contract. You have the ability to mitigate damage. You cannot come after us for damages given that we're giving you the ability to mitigate. What's more, there's hardship here. You should be acting accordingly. And I would tell you that in the 3 or 4 times that I have sent such a letter to the builder, every time, and this is only in instances where they don't permit assignments, every time the builder's lawyer has called me and they've said, Mark, I want you to keep this under your hat. We'll permit the assignment in one instance. We're going to give you a a confidentiality agreement. If this gets out, this will be terminated, but we will allow it. And it's happened every single time. Again, not because we have legal rights, but simply because we're pushing back. And as if someone who worked for a big law firm, I'm not going to call you out, wants to comment, you'll see that upon receiving a letter like this, one of those law firms just don't know what to do because this doesn't fit into their box. This isn't one of the normal letters that they get. And because it's not one of the normal letters that they get, it doesn't go to a law clerk, it goes to a lawyer. And then the lawyer starts saying, ooh, this doesn't, you know what, do I really want to put up with this? Even if they're going to lose in court, it looks like they understand the basics of law here. Let's just grant the indulgence. I have 17 other things on my plate, done. My builder's not going to experience any damage. Fine, we'll deal with this that way. And that's what happens. And as a result, you've done your clients a service, even though under the letters of the law, we don't have the ability to do anything. Any questions on this before I move to the next point? Anything? No? Okay, let's move on. How about disputing minor defaults? Can a builder terminate an agreement for minor breaches, such as a late deposit check or failure to come up with a financing document by a given day? Oh, whoops. Practically, I'm sorry, this is written wrong. Let me just fix this. Practically, perhaps not. There we go. Can a builder terminate an agreement for minor breaches, such as a late deposit check or failure to come up with financing? Legally, the way a contract is worded, yes, they absolutely can. Time is of the essence in these agreements. There is ample case law that suggests that if something is time is of the essence, granted, and it's a real estate contract, failure to live up to terms does cause breach of the contract. Sorry? Sorry, did someone say something? Okay, I guess not. Does cause breach of the contract, and there is strict construction. That is the term in law. There is strict construction to these contracts, such that they're really, if they claim breach, a court would uphold that breach. So what do? Well, again, we've got to break free of the normal letters that these large building shops are expecting. To that end, we use Section 98 of the Ontario Courts of Justice Act, which states that a court may grant relief from penalties and forfeitures on such terms and compensations as are otherwise considered just. Now, this is largely used in the lease realm, particularly commercial leases. If you default on a commercial lease, a landlord will always let you back into the premise because it is well known that a relief from forfeiture application will have the courts reinstating the lease. It's a minor breach so long as you bring it into rectification. It is not used for real estate contracts. It would probably fail if you use it for real estate contracts. But that doesn't stop us from using it for real estate contracts. Dear sir or madam, we represent client X who is presently intending to purchase a property from your client, builder Y. We have received your correspondence noting our client is in breach of the agreement and canceling the contract in accordance with the contract's stated terms. So just acknowledge it. We're writing to inform you. We are writing to, oh, sorry. You can tell that I did this 5 minutes before this started. I apologize. We are writing to formally request that you withdraw your notice of default on the basis of the equities of my client's particular situation. Again, just copy and paste it about the wolves and the hyenas. My client is in a position to cure the default that gave rise to your notice immediately and will commit to ensuring that this does not happen again. My client intends to make this house her home, and canceling this contract will deny her and her children their intended habitation. Boo-hoo, sob story. We are, in effect, asking the builders relief from forfeiture as one would under the Section 98 of the Courts of Justice Act. We thank you sincerely for your attention to this matter and look forward to a positive response to this correspondence. Sincerely, a lawyer, delicately intoning that there's some legal threat behind this meaningless letter. You will note that as part of this letter, I did not punch the bully in the nose. I did not say to the builder, you do what, and this is a good understanding of how lawyers should be drafting letters. I did not say, you do this or else I'm going to Courts of Justice Act, slamming it down. What I did was I intoned. I said, we are asking for this as we would Section 98. Now, I assure you, a real estate lawyer who is doing nothing but conveyances has no understanding of what Section 98 of the Courts of Justice Act states, but they will be interested. And what's more, stating that means that the clerk is going to immediately flop this on a lawyer's desk, and the lawyer is going to look up and say, oh, this is interesting. It looks like they may have something here. They don't know all the case law, and even if they do, they understand that you understand that there may be an avenue to getting the courts to listen. And at that point, what are they going to say? The person who is swamped with 17 files and dealing with major issues has that their client will be made whole, and you'll go away if they agree. And invariably, where we've had to send this letter, they have sent back a letter saying, okay, but this is a final chance. Here you go, we're reinstating, let's move. Because they don't want to have to deal. They aren't litigation shops. They don't want to have to research the law. They don't want to have to transfer the file. They don't have mechanisms for that. They don't care. That's not who they are. And so when you go ahead and gum up the works and throw these things at them, which they are not used to and which they do not know, what you are doing is you are pulling it out of their workflow process. And I will speak, when I ran Access Law, we were dealing with thousands of files, hundreds of thousands of files over the course of many years. And I will tell you that the worst thing in the world was when minor difficulties took place that didn't fit into our workflow, because suddenly individual attention had to be brought to bear. And the last thing I wanted was to deal with that. And I would do anything to get rid of that so that my system would start working again. And it is no different at the large builders. And so again, the goal of fighting the builders is to gum up their workflows. Because the moment you do, you will find lawyers who are ready to concede so that the workflows start working again. This is not legal advice. This is just practical. But practicality is all we have in a world where builder contracts are ironclad. Does that make sense? David, did you want to say something?
I didn't want to say anything, but I completely agree with you 100%. And similarly, you have to get right at that lawyer, and the way is to just explain the law a little bit, which is amazing. And
Awesome.
I'm walking. It's very windy where I am, so I'm not sure if you can hear me.
Nope, we can hear you perfectly. So no problem. Okay, let's talk about other ways we can fight the builder. So one way we can fight the builder is by using carry-on, because carry-on does supersede the builder contracts. Of course, carry-on sucks. It absolutely sucks. In fact, if you look up my name and carry-on on the website, on the internet, you'll see I was the feature of a Toronto Star article some years back. Justice Cunningham was doing a review of carry-on, and I was one of the people who was representing a good mass of people in Ontario. And Justice Cunningham was doing a review on behalf of carry-on, and I got in touch with his office and I said, I want to speak on behalf of purchasers. I want to speak on behalf of small people. And I was given in writing assurance that I would be given the opportunity to speak. And then they released the report without even calling me to the table, which shows you how much they actually care. But that they did hit the Toronto Star, which shows you how much they actually care about hearing from anyone who isn't a builder. They really, really, really suck. And if Tarion is listening to this, I have a simple word for you, or I have a simple message, which is you guys suck. Having said that, they do provide certain protections. They give you the right to quality construction, pre-delivery inspections, 1, 2, 7-year warranties. I'm going to skip number 2 for a second. They give you a right to a maximum square footage. Like if in fact you come in and your unit size is significantly smaller than what was anticipated, which I have seen happen, by the way. In fact, I saw it happen on, well, it's public, actually. You know what? There was a lawsuit about it. So it was the ICE condos downtown. There's suddenly some people got units that were significantly less. You can sue on the basis of the Tarion guidelines. By the way, the 2% is a bit mistaken. You think, oh, 2%, that seems reasonable, fine. But what actually happened in those instances was they made the balconies larger and they lowered the inside units, thereby still maintaining a 2% variation. But, the usable space of the condo was significantly reduced. It was nuts. Actually, that wasn't that case. I'm sorry, that wasn't the ICE condos. That was a different case. But you can see it's 2% over the whole unit, not over the rooms. And we can go into details as to how it works. They also provide deposit guarantees, $40,000 for condos, 20,000 of which comes under Tarion and 20,000 comes under the Condo Act, and up to $100,000 for homes. That's useful, I guess. I mean, not so much for condos because most deposits are now 25%. If condo price is usually $600,000-700,000, and you're going to vastly exceed your $40,000. But I mean, it's better than nothing, I guess. There it is. Where I can give some advice is in the timely completion of the project. There's a menial amount of money that is given to you, $7,500 for builders that delay, up to $150 a day. Generally, if builders find that it is owing, they will approach the clients without actually approaching their lawyers, asking them to sign it away, basically saying you agree to this and this now vitiates your compensation under Tarion schedules. There's no rhyme or reason for anyone to sign that. Everyone who asks me, I look at them and I say, do not sign this away. The builders just try to get away with it. So part of fighting the builder is make sure you're entitled to your $7,500. Do not sign that away. Do not sign that stupid form. Just get back to the builder, say, I won't sign this, and they won't push it because they understand that it looks very bad to be trying to undermine the Tarion system. I've never had a builder push back when you say, no, I'm not signing this. I have had clients who are worried saying, but won't the builder hate me if I do this? I have to agree because they're going to install my kitchen sink the wrong way. To which I just laugh and I say, if you think the builder knows you worth a darn, you are kidding yourself. Don't worry about it. Don't sign this back. So I'm going to point that out because that is a simple way that we can fight. And I see that David is putting up his hand and obviously agrees. All right, let's turn to another one that you guys care about. Demanding prompt payment of commissions. Builders are notorious for withholding commissions from agents. Do agents have the right to timely payment of commissions? The answer is, with good builders, yes. With bad builders, legally, no, but practically, maybe. So the sad truth is that under a normal agreement, you do not have a right to a timely payment, but you may have a common law right to payment. And I'm going to address that in some detail right now. First, I'm going to address answer 1. With good builders, yes. So I'm just going to share my screen in a different way. Let me just quickly, hold on, please. Move this. New share. Can you guys please confirm that you are seeing what it is that I have put on the screen? Can someone just confirm that they see the Realtor Cooperation Agreement? Okay. So I see that I left one.
It's small. It's very small.
Okay. Well, I don't really particularly care because I'm not going to go through the details, but this is from Tridel. Tridel is a good builder. Minto is a good builder. Daniels is a good builder, always overpriced, but a good builder. And by good builder, I don't only mean the quality of construction. I also mean that they deal with enough realtors that they have set out an actual formalized agreement which realtors sign. And this agreement is much more detailed than anything you've seen on a residential agreement. Look how detailed it is. It's massive. It's 7 pages long. And it's great. It has the details of when the payments shall be had, when it shall be made, what all the provisions are, what the obligations of the parties are. I love it. Why do I love it? I love it because when someone says, I'm not being paid, and I say, do you have any paperwork? They say yes, and suddenly we're bound in contract between the agent and the builder, and you could say, hey guys, pursuant to Schedule A of the confirmation of cooperation, which I herein attached to this letter, here is when it should be paid. We haven't received payment, please pay. It is a contractual claim. Bob's your uncle. We are done. Beautiful thing. Mwah. I live in a somewhat Italian area of the city. I'm allowed to do that from time to time. Simple, straightforward stuff. And I love it. And every one of you as agents should be asking for this, or asking for a realtor cooperation agreement when you bring in your clients. Now, don't get me wrong. Builders may very well say, the hell with that, we don't have one. At which point you're just going to shrug and you're going to say, well, this is 4%. I'm doing no work. I'm just going to do this and you're going to get it signed. I would do the same thing. But it doesn't mean that you shouldn't be asking. What's more, if you have an example like this and you give it to the builder, you could say, look, here's what I just signed in my last one. Can you please provide it? And some builders who are new quickly take a look and go, ooh, good, yeah, no, I should have something like this. And then they put something together for you, which I've seen as well. All well and good. But what happens if the builder doesn't provide that? I mean, we've all been, well, I'm assuming many of us have done builder deals. Oh, hold on, sorry, 1 second, please. Richard, I'm gonna answer your question after I'm finished this segment, okay? What happens if the builder doesn't provide this? We've all done new builds. Many of us have done new builds here. And it's very clear that some builders have you sign one paragraph. Some don't have you sign anything at all. You just leave a business card. So are you entitled to claim commission at that point? Forget about timely. I mean, no, you don't have any right to timely because there's nothing written down. So commission would be payable some point after the final deal has concluded, would be a reasonable position. But can they deny it? Well, I've seen it. I've seen them say, sorry, no, we have no record of this. We're not paying your commission. What do you do? Well, in that instance, you revert to the common law. So let's review a claim to commission within a common law framework. Claim here to commission. Again, I'm sorry, I did out this presentation about 5 minutes before we started, so I'm sorry about this. So the Supreme Court of Canada came out with its most recent unjust enrichment case. So everyone in first-year law school learns about this great thing called Petkus and Becker, which was the case that set out what's called unjust enrichment. If you go ahead and you do work for someone else that benefits them, which they don't stop you from doing, and they later claim, well, there is no contract, then you can make an unjust enrichment claim. Generally, unjust enrichment is used where there are common law couples who have no contract as between them, where they've been married for, say, 30 years, and the wife or the husband has not worked, and the other partner has, and if they were married, they would be able to claim equalization, but because they are not married, there is no equalization. The courts have therefore determined that they are entitled to what is effectively equalization through unjust enrichment. One party is substantially benefited by the other party sitting at home taking care of the kids. But unjust enrichment is a general concept in law that works well beyond maritable disputes. In fact, Petkus and Becker dealt with a farm. So the original unjust enrichment claim in common law dealt with something else. If you are able to show, and this is the most recent Supreme Court case test, that one person received a benefit, that another suffered a loss corresponding in some way to that benefit, and that there's no jurisdiction reason for the benefit of the loss, then compensation for services is due and owing. And if you can do that, then you claim damages. What damages do you claim? You claim a damage called quantum meruit. Quantum meruit means the amount deserved. I guess the amount, I'm pretty careful in my presentations of writing she and he, and I copied and pasted this from the first Google search that came up, so I apologize. So quantum merit means the amount he or she deserves, or as much as he or she deserves. So in the event that a builder refuses to pay commissions and is found to have been unjustly enriched, the courts could order what is deserved, which in this case is the percentage advertised by the builder, or what a reasonable builder would pay in the circumstance. So here's our letter. Dear sir or madam, we represent agent representing client X who purchased a home from you in the past. Our client informs us that you're refusing to pay his or her commission, and I have seen this happen, for the above noted deal, as in your words, there's no signed documentation attesting to any amount due and owed. With respect, your position is wrong at law and equity. Attached to this letter, we again need to review this before we start this. We enclose numerous pieces of correspondence between yourself and the agent, showing that he brought in the deal to your office, and that you worked together to bind the client to the agreement that was eventually signed. Note that I really need correspondence. And so if the builder is stupid enough not to provide you with any sort of documentation, such as we have discussed before, the new build co-op agreement, well, then you sure as heck should be emailing saying, it was a pleasure. I'm so glad I was able to bring in this client today. I'm looking forward to working with you in the future with future clients. You need email correspondence from that time to show the world that you in fact brought in the client. So if the builder doesn't provide it to you, please, please, please send correspondence, thank you emails, and everything else to the builder so you have that in your file. The agreement was signed. The agreement signed was the document that you yourself drafted and required signed without amendment. And at the time, you promised the compensation would be accorded by noting the agent's name with the file as per what you term normal convention. Many builders do this. I've been subject to this myself. I see it, and I know all of you have experienced it too. It was clear that you were broker protecting registered agents for 4% of the purchase price. To sum up the situation, my client brought you his or her client. You signed an agreement due to my client's work, and note that this is exactly the three-point test we had just talked about. You signed an agreement due to my client's work in securing that client, and you were enriched accordingly. Actually, I'm going to say not enriched. You were unjustly, actually, I'm going to say enriched accordingly. That's fine. I like that better. You are now claiming that there is no reason for the benefit accrued to you and that my client lost his ability to bring his client elsewhere. My client is, simply put, entitled to the amount that was advertised, 4% of the purchase price plus HST. And now you show your hand of it. My client is a prominent one. Quite apart from the negative stigma that this lack of payment will cause amongst his or her colleagues, it will also cause a problem with your purchaser, as absent an agreement from the builder to pay commissions in the manner expected. My client's only recourse will be to pursue its own client for commission per the signed buyer representation agreement, and have them seek compensation from you for failure to live up to your own promised commission structure. In other words, A, I have rights at law under unjust enrichment. Although I didn't say it exactly, I threatened it. And when it goes to a lawyer, they'll understand unjust enrichment. They'll understand what I'm saying without being a hard prick bastard. 2, you are going to have problems with the realtor community. And that's the last thing you want because you're going to have other projects. And 3, you aren't going to get away with this because I still have legal recourse as against the person you do not want me to exercise against, the purchaser, because the purchaser will turn around and cross-claim against you. And at that point, evidence will be induced, and a court, realizing that an innocent third party, this client, is now going to have to pay commission because I have him roped in by a BRA, will likely find against you. At least that's the way I would interpret it. We thank you sincerely for your attention to this matter. Lawyers saddened by what you're revealing about life, the universe, and everything. In the 2 instances in my career where I've had to write this letter, it has worked. Again, do we have a legal claim to this? No, there was no document signed. They can claim whatever they want. It's hard when you don't have legal documents. Will it work? Yes, likely will work. Why? Because you are destroying the edifice that the builder has built up in their legal office, the workflow machine. You are forcing this to come out of the natural workflow, and in doing that, they will give anything to get back to the normalized schedule of default letters that simply come out of their printer like clockwork when timings are missed. So Richard writes, What about the co-op agreement? They have scheduled commission payouts. Is that not a contract? Yes, it is, Richard. And that is very similar to what it is I pointed out before in the new build agreement that I pointed to. But you are privileged if you are dealing with a builder that has that. And yes, you can just sue and contract on that basis. And if they have it, a simple letter saying, here it is, it's owing. By the way, you are not allowed to drag your feet on this. There are timelines contained. And if you are dragging your feet, it is contrary to the agreement. You're in breach of the agreement. And we can sue you for breach of the agreement. So yes, we have all the rights in the world if they have a scheduled commission agreement, which is why good agents and every one of you who've now attended this lecture will absolutely ask for that every single time. But where this issue becomes an issue is usually not with Tridel or Daniels, sometimes it's Daniels, but Tridel or Minto or others. It's usually with mid-sized builders or small builders who simply don't pay these things in timely manners and usually don't have the contracts with the scheduled commission payouts. And we have to deal with those. And that's really where, if you think about the stigma and if you think about areas where you've been screwed by having to wait months and months and months for payment, it has been with those builders, not the larger ones, I would bet. So did that answer your question, Richard? You can just text if it didn't. So guys, it's 10:50 and I'm gonna open it up to questions. Hit me up, what's up? Oh, and I'm also gonna flash my details because random advertisement. I'm available for legal closings. P.S. as David and Sonia have sat there this entire time, they are too. But I happen to be the good-looking lawyer whose voice you have heard melodiously for the past 50 minutes today. So I get advertised. What questions do you guys have? None?
You leave no stone unturned.
Sorry?
You leave no stone unturned.
Oh, well, thank you very much. See, I can tell that my check cashed. That's fantastic. Who said that?
Jack.
Ah, okay. Well, see, again, this is why you should pay off the people who attend this session. They give you nice comments for posterity. Can you walk through where we can find the development charges when we sign up the client? Yeah, all you need to do is actually, it's really simple. It's a Google search. So if City of Toronto, literally type City of Toronto development charge schedule into Google. It will pop up. All you need to do is look at the date of your agreement and then simply look at the DC charge schedule. It's that simple. If you have any problems with it, DM me and I'll walk you through it. Anything else? Nope. Okay. Guys, thank you as always for attending. I appreciate everyone coming out to these things. Next week, I think we're going to do an update on Bassin and Harnu and good faith and what it means in the case law, which actually should be interesting. And I will commit to you that not only will that be interesting, but I'll also pre-review the presentation before I actually give it, such that we don't have minor errors that I have to correct while I work through things. Thank you very much, guys. Have a great day.